Hello, everyone. Thanks for joining us again this week. This is MDC Connect, and this is the fourth and the penultimate webinar in this series that runs every week on a Tuesday at 1 o'clock. I'm Sarah Brockbank, and I'm hosting the session today with my colleague David Pennington, both of us from MDC. So each year, Medicines Discovery Catapult aims to connect the community by running a short series of weekly webinars. And we're joined from experts from across the community, along with our own experts, to provide sessions that are here to educate and inform the community. In previous years, we've run drug discovery webinars, very much with a focus on the science. But in response to the challenges in the current climate, this time, we're outlining the journey from innovation to commercialisation, and we are enjoying really quite a lineup of speakers this time. We've got funders, or we've funders and venture capitalists. We've had CROs and science parks, patent attorneys and TTOs, and big pharma joining us, all freely giving their expertise. We started out the sessions in the first week by setting out the challenges, and then in the subsequent sessions we are addressing those challenges, and we have addressed securing funds, where we were joined by Innovate and by venture capitalists. In the week after that, we were building the science and addressing the challenges of finding lab space, securing skills, accessing the capabilities in the CRO sector. And today we will be joined by patent attorneys and a TTO from Newcastle to talk about how to generate an IP strategy which is fit for your business. And finally, in the last webinar, we'll get to crunch point and we'll talk about the all-important commercialising your innovation. So today I'd like to welcome three speakers who will discuss how to secure your IP to ensure your successful commercialisation. Firstly, we've got Catrina Carroll, who is the Intellectual Property and Research Funding Lead from MDC, and she will outline the different types and levels of protection and what's suitable for your business. Then we've got Geraint, who's Head of Enterprise Services at Newcastle University, and he will describe how university TTOs facilitate spin-out businesses. And finally, Naidu, who's a UK and European patent attorney at Marks & Clerk, and he will share how to prepare your IP for a due diligence process. At the end of each of your, at the end of each of the presentations, there will be an opportunity to ask questions. If you could put your questions into the Q&A box at the bottom of your screens, not into the chat box, please put them in the Q&A box at any time during the presentation. We will pick them up at the end of each talk. So over to you, Catrina.
Thanks, Sarah. Just gonna share my screen. Is that coming up okay?
It is. Thanks.
Right. So hi, everyone. Thanks for joining today. At the Medicines Discovery Catapult, we generally work with small, medium enterprises or spin-outs from universities. And IP is a critical part of their commercial journey, but they usually don't have a lot of money to spend. So I'm going to talk to you today around how you can create cost-effective IP strategies by doing some work upfront before you engage with external IP or patent counsel. So the first thing I want to talk through is, why is IP important? So some of these might seem relatively obvious, but with regards to IP, you can register specific types of IP. This gives you legal protection. It safeguards your innovations from other people using them or exploiting them, which can ultimately affect your future revenue streams. By creating smart IP strategies, you can protect unique aspects of your innovations that offer novel value propositions, creating differentiation from competitive offerings. IP enables business growth. Developing strong IP strategies means that you can maximize or exploit new revenue streams. So an example of this might be for the CRISPR-Cas patents that we all know. They protected their invention, but they also protected derivatives of CRISPR-Cas modified technologies. That creates a whole new revenue potential for their products. Most of our SMEs are constantly in the process of raising venture capital, and intellectual property is a core component of that valuation equation that venture capitalists and other types of investment organizations use. And sometimes we often forget this within the life sciences and therapeutics, but IP is a critical part of building your brand identity. So protection of distinctive logos, names, and designs. So I'm just going to whiz through this. This is going to be available afterwards for you to look through. And this is just some fundamentals around the different types of IP protection. Within the therapeutic space and life sciences, we are very IP rich with a specific focus on patents. Patents are technical documents. They go through a registered process that is part of an examination, and you have to meet specific criteria in order to get your patent grant, which I'm going to talk about next. They provide you protection 20 years from the filing date, so not the grant date, but the filing date of your patent. And these are territorial rights. They are relatively expensive depending on what territories you decide to protect your invention in. The next three, I'm not really going to talk to. Like I said, the slides are available afterwards. I just wanted to mention trade secrets and data, because if you're a small organization and you don't have a huge IP budget, actually not protecting certain aspects of your innovations can still be a valid IP strategy. So I wanted to separate out data from trade secrets, because the dawn of AI means that data is a very, very important asset, and actually classifying your data assets can be a really important way to create value for your company. You protect these types of IP generally through either keeping them secret or through confidentiality, like CDAs or confidentiality provisions within your agreements. The cost really depends on, the contracting that you need to do, how many people that you might have to disclose this through in confidential agreements. So for the remainder of the talk, I'm mainly going to focus on patents. Like I said, we operate in a very patent-rich sector. Patentability relates to the conditions for patent eligibility, and these are really important criteria in order to get your patent grant. So the first criteria is that your invention needs to be novel. This is a very black and white criteria, and it basically means that you can't have previously made public in any form, or someone else have made public in any form, in any territory, the specifics of your invention. And this is before the patent application is filed. So the prior art is considered before the filing date of your patent application. The second criteria is that it has to be non-obvious. This is where we start to get into more of a gray area and how you can start to develop your IP strategy. What this means is that it can't be something that someone could easily come up with who has knowledge and expertise in the field. And when we talk about someone who has knowledge and expertise, we don't necessarily mean someone who is at the cutting edge within that field. I usually like to think of it as in terms of someone who's at the research assistant or PhD level. And the third aspect is often forgotten, but you have to have utility. Your invention has to have some industrial application or benefit, and you need to show that it's actually feasible that it could be used. There needs to be some evidence or data there. The data requirements aren't as intense as you would need for an academic kind of application, such as publications, but you need to show that it is feasible. And some other important considerations include inventorship. There's legal definitions related to who can be an inventor, so it's really important to get those right up front. Ownership, who actually owns the IP, and then freedom to operate, which I'm going to talk about later. So what can you actually do to start thinking about whether your innovations are patentable and then also potentially have freedom to operate, which I'm going to mention a little bit later? Well, there's lots of free databases that you can access in order to do some of these prior art or patentability searches upfront before you engage with external IP counsel. So one of these is the World Intellectual Property Office's Patent Scope. It's an extensive database that is related to what we call PCT applications and then the national patents that come from those within multiple jurisdictions. You can search on text and you can search on specific classification codes, and you can also search for chemical structures. So it's a really powerful free database. And there's also a lot of really useful information and tools just generally on the WIPO database. The second one is the Global Dossier. So this is provided by the 5 major IPOs, and it contains all the examination proceedings related to patents within those specific IPO offices. So you can look at the communications for specific patents between the examiner and the assignee or their patent counsel that's represented them, how the claims evolved during the examination process. And this could be really important if you're looking at pending patents for freedom to operate, for example. And the third one, which I'm sure a lot of people use, is Google Patents. So it's a relatively robust search engine, and you can also search things like non-patent literature, so publications, for example, which is a really important thing to do when you're doing your patentability, because non-patent literature also counts as prior art. So how do you do these patent searches? I'm going to talk on my next slide a little bit about how you can use AI to help you structure your searches if you're a bit of a patent novice. But the first thing to say is that you need to create different search methodologies. So you can do this by searching just on keywords that are relevant to your invention. You can do classification-based searches. So patents are indexed by specific classifications, and you can search on those or refine on those. If you're looking at competitors, you can look at specific companies, you can look at inventors, you can filter on the country, and you can also do date searches. A combination of these different searches mean that you'll come up with an initial list of patents. It's then good practice to repeat the search with additional or alternative search terms or synonyms, for example. When you're doing something like patentability analysis, you might then want to read the patent abstracts to see what things are going to be most relevant to your invention and then filter on that. However, if you're looking at something like freedom to operate, and I'll talk a little bit about this later, you might instead want to look at the patent claims, because that's actually what's protected within the invention. And then finally, hopefully what you'll get is a list of relevant patents. And this is a good point to actually start engaging with external patent counsel in order to do the analysis and get a professional opinion on how these patents might affect your patentability or freedom to operate position. So AI is such a useful tool, and it's also useful for helping to build your search criteria for patents. My only caveat is that usually what you put in the chat is a public disclosure. So please be very, very careful about what information that you're putting into the chat, and generally keep things quite top level, or actually just use it to guide your searches. So this is just an example of something that I did, which was to build search around an in vitro kidney organoid that could be used to test drug toxicity. There's products like this already on the market, so that's probably not a disclosure in itself, but you could have, for example, a novel method of creating the kidney organoids. I've asked the chat to use Boolean search operators because these are generally what is used within the patent databases, and you can go on the help page of each of the free databases to see what the different search operators are. But you can see ChatGPT is giving you a lovely different methodologies for creating your searches, and you can do lots of different combinations of these searches in order to create a really robust search methodology and find those critical patents. So freedom to operate, I've talked a little bit about patentability, but what is freedom to operate? What are the different things you need to think about when you're searching patents? Freedom to operate is really about other people's IP and whether you're infringing other people's IP rights by doing your commercial activities. Importantly, patentability, you need to take into account non-patent literature, but with freedom to operate, it's very much focused on patents themselves. So that can help with your searching. It's also focused on active patents, so things that are potentially revoked or things that have expired wouldn't necessarily be relevant for freedom to operate. It's pending or granted patents, and it's specifically their claims. So that's part of the patent document that protects the specific invention. Um, and rather than other aspects of the patent document, for example, different parts of the text that you might have, which you would need to assess for patentability. Now, like I said, patents are actual territorial rights. So when you're looking at freedom to operate, you can also filter on relevant jurisdictions. So where are you commercially active, rather than searching across different territories that you may not be commercially active in. Unlike patentability, which is something that is from the date prior to you filing your actual patent, FTO is something that you need to constantly monitor, because there's, in theory, patents that were filed after potentially your patent filings that could affect your freedom to operate status. And it's important to identify these early so you can take proactive steps. And Anise is going to talk a little bit about this later. So what happens, for example, if you find a pending patent that you think could affect your freedom to operate? Well, Global Dossier is a really good way to monitor patent examination proceedings, particularly for pending applications that could affect your freedom to operate. Usually the patent databases, they will give you the published patents, but what the Global Dossier allows you to view is the cited prior art, the communications between the examiner and the assignees of the patent or the assignees patent counsel, the objections, and then really importantly, any amended claim sets. So usually people's patent strategy is they'll start out relatively broad with their claims and then go and refine later on. And this lets you see how the claims are being amended. This allows you to make a better assessment on the strength and the scope of the pending claims, the type of legal arguments being made, and allows you to inform your FTO strategy and your FTO status. So my final tips, first is stay informed. You need to regularly monitor your patent landscape. You can do that quite efficiently with the free tools available. This allows you to stay up to date on new filings and also granted patents, and allows you to take those proactive steps to things that could affect your FTO status or your patentability assessments. Engage early. These type of IP searches, they shouldn't be done once you have the final product. They should be done integrated as part of the innovation process, because they may inform how you do your innovation and the type of data that you want to generate. I've talked about how you can generate some data upfront so that you can cost effectively engage with external professionals, but I do encourage you to engage with professional IP attorneys, etc. Particularly for complex analysis, and also trying to get legal opinions on FTO, because doing the analysis of specific claim sets can be quite complex. Document your process. So this very much refers to Anise's talk that he's going to give a little bit later, but keeping detailed records of your FTO and patentability searches are really important, potentially for due diligence related to raising financing, or actually for doing licensing transactions with third-party entities. Use the insights that you get from freedom to operate and patentability analysis to make strategic business decisions, and also to inform your IP filing strategies. And I think that's everything. So happy to take questions.
Thanks, Catrina, that's great. So we've got a couple of questions in. We've actually got a couple here that I'm going to join together because they're very similar. So are there any platforms or tools you'd recommend to streamline this for a small company? And the other question related to that is, are the tools expensive and what budget would be needed?
Yeah, so the tools that I discussed today are actually freely available tools that you can get. You don't have to pay anything, you can just sign up to them. So that's really good. In terms of, is there any way to, if I understand the question, automate the searches? I would say is you're always going to have to do a little bit of work there yourself in order to do that. But once you've got search functions set up that you think are relatively robust and you validated, for example, you can set alerts on those then to continuously monitor if there's any new filings or any new specific actions within patents that you're looking at for freedom to operate, for example, to help stay up to date with what's happening and inform your strategy.
And what might be some common challenges when using the free databases?
Yeah, so the free databases are a little bit more limited in terms of the coverage that they provide compared to some of the paid databases. So, for example, with the WIPO's patent scope, generally it's based off people who filed PCT applications initially and then national applications following that. So there could be specific national territory filings that may not be potentially represented within that. The other potential limitation is around translation. So, a lot of these you can search mainly within English text, and the paid databases will do automatic translations for you. But I think if you're operating within a tight budget, these are a really good actual first port of call before investing in something like a more robust database, essentially. And you have to think about the territories as well that you're interested in, for example, particularly related to freedom to operate. So as a first port of call, these are great databases to use. And then as you grow and evolve and you grow your budget, you might want to invest in one of the paid platforms.
Okay, brilliant. Thank you very much. You've actually got quite a few questions there, Catrina, in the Q&A box. If you want to type some answers in for those people, and we will crack on and hear from Geraint now.
Great. Okay. Thank you.
Yes, thank you. And good afternoon, everyone. So my name's Geraint Lewis. I lead the team that kind of manages the invention disclosures, IP management, and the commercialization and licensing of our IP to commercial partners or spin out. And I'm hoping today to give you a little bit of insight to the approach that we take at Newcastle, but there's a lot of commonality in what I'll be saying with the approach that a lot of universities take in how we kind of assess our IP and how we prioritize what IP to kind of protect. I thought I'd start off with just setting scene a little bit of why we protect IP at the university and kind of how the process kind of works closely. I should probably put my hand up first that I have taken this image from another source, which I somehow cropped off the copyright, but it is a US university and I'm very thankful for them allowing me to use this. But in short, we have ambitions, aspirations, a mission, and our funders require us to generate impact from our research outputs. And if that impact is best served by going down a commercial route, so whether it's a spin out of the university or a license to an established company in a sector already, then we are probably then going to be looking at protecting the IP formally through registered IP rights. And within the university sector, certainly within Newcastle, that is predominantly through patents that we seek to protect. We hardly ever get involved in anything to do with trademarks. It probably doesn't really add value, and we view that as being effectively the onus is on the commercial partner to take forward. And registered designs are still pretty uncommon. I think maybe once in the last 10 years that we've actually applied for registered design. So we are talking about patents when I kind of talk about IP protection within the university sector. And how it kind of works within university is we get research outputs. And I've always quite liked this image for the simple reason he actually talks about pre-disclosure phase. And I know there's a few people on this call who are from the university sector. We actively encourage researchers at Newcastle University to get in touch with us really early. If they've got an inkling that they might have something that could be protected, or they think there's an innovation or commercialization opportunity, we encourage them to talk to us at an early stage. Gives us an opportunity from the TTO to better understand what has been developed. We can probably give pointers on what to look out for. We can probably also reinforce the message to be mindful not to disclose, publicly disclose any IP before we've been able to protect. But the way the process normally works is that we get towards probably the end of a research project, the formal disclosure form, like an invention record questionnaire comes through. That gets assessed by my team. We're looking at the commercial, the IP, protection capability within there, which Catrina kind of outlined, and this will build on. The assessment stage, I'll talk a bit more about that because that's a key driver to how we go about protecting our IP at Newcastle. We then look, if it's a valuable opportunity and we think we can commercialize it, we'll look to protect it through patents. And then we've probably got the option then of either taking it through a spin-out route, if that is viable, or we're going to license it to an established company. So we do a bit of marketing, pushing it to interested parties. Hopefully we get a license deal, they'd take a product or service to market, and then we get an impact story as well as some kind of revenue share back, which eventually goes back into funding research in some form at the university. So that's kind of the outline of how the technology transfer process works from the university into industry, and funny enough, the returns that come back from that. But I particularly want to focus on the assessment stage of this, because this really just drives our decision making on what to file on. And from our point of view, the focus and the crux of it is trying to understand what is the end game with the invention. What is that business model? What is the product and service that the invention is aiming to serve? And from that, we can probably work out then what is the kind of technology and IP requirements to achieve those goals. The other thing we do is deep delve into the industry sectors, understand the competitors. This also helps us understand the models our competitors are using. And importantly, we're trying to understand the value proposition of the invention. Why is it more compelling for Mr. and Mrs. Jones to choose Newcastle's technology, or for company A to choose our technology above that of other competitors in that space? The other thing we do as well, I think Catrina highlighted this well, is that we also look at the IP strategies of our competitors. So we look at what are they filing, which might help inform some of our thinking about what could be filed in the future around our IP, and where they are filing it, which countries and territories they are taking and maintaining those patents in. And that's quite an important point from a university perspective because of the budget constraints that we have on being able to take it into any country in the world. And the eagle-eyed of you may have noticed that the first 2 points, which kind of are similar continua, are totally focused on the commercial side of the opportunity. We don't really assess the actual IP until probably our third step. And in that point, then we're trying to understand what are the key IP assets within an invention that is going to be most valuable to achieve the business model, the business objectives that we've kind of identified. And then we assess them, as Catrina kind of outlined. Novel, inventive step. We consider freedom to operate as well for our IP. 1 and 2 are key for us because that helps frame what we are assessing when it comes to the IP assets that are disclosed in our invention. And it gives us a focus. And then on the 4th point, we then consider the value of the IP and how we're going to protect the IP, how that's going to support any licensing or spin-out plans that we may have. We also at this stage have to carefully consider the timing of seeking the IP protection. University classically, sometimes we do get early disclosures. We may not have sufficiently exemplified an invention to be able to even seek IP protection, or we may not have achieved sufficient proof of concept or data package that would convince a licensee or an investor to invest in the spin out. So I've distilled into 4 points. That's kind of summarizes kind of the approach we take at Newcastle, and it's probably very similar to pretty much every university. What we're probably trying to emphasize here is we probably don't worry too much about what the IP is that's developed. We're trying to understand what the business opportunity is and how the IP supports that business opportunity. And I guess if we come to the point and the IP is something we want to file a patent on, we kind of follow this process, which involves taking advantage of the Patent Cooperation Treaty procedure, or the PCT phase. So presume we file a patent at month 0, we will always pretty much file a patent in the UK. What we will, and that then effectively sets off a clock for us to then do a number of things, because we try to, before the 30th month after filing a patent, try and make sure that we've explored all the commercial opportunities for the opportunity. We're trying to identify and ensure we've got the market fit for what we're proposing. There's clear market pull. We're trying to identify licensees for the opportunities, or even investors. And critically, we're trying to understand what is the data package that any licensee or even an investor may be looking to see before they will part with their cash or enter into a licensing agreement, etc. And we try and do that over a 30-month period. And the great beauty of the PCT and taking it into the PCT phase is that it buys us an extra 18 months to try and get that information pulled together to validate the opportunity, and that it's worth pursuing. From a university TTO, we then utilize a lot of resources to try and achieve answering those questions from a commercial and technical development angle and data package. So we effectively access something called IQA, which I would greatly endorse for people that can access this program. It's a great program for market validation, understanding your business model. It's hugely helped us identify early customers, actually, for some of our spin-outs. It's open for universities to access. And then from a technical development, we're trying to progress the technical development using internal proof of concept funding that we might hold. So classically, your impact acceleration camps, confidence in concept. Most of the research intensive universities would have that funding pots available. But also I know some universities have their own individual proof of concept pots. And we also access external funding, such as MRC's DPFS programs. I know they've got an earlier program you can access, and BBSRC follow-on funding. And we're trying our best to try and accelerate the commercial de-risking, the technical development, data package development, all in a 30-month period before we get to the decision on national phase. The reality of it actually is that we can often complete our commercial due diligence and be confident we've got a commercial opportunity way before the 30-month mark. However, unfortunately, our technical development data package that we need to develop is often, it lags behind. And quite often we go beyond the 30-month phase. And the issue with that is just the timing of when we can access these funding pots. Sometimes we have to access more than one funding pot, and it doesn't nicely fit in with that figure that I'm showing you on this slide. At month 30 and 31, as Europe, you can enter 31-month point. It's really important for us to kind of understand the key territories that we need to go into. And this is why talking to potential companies in the fields, even competitors, and even reviewing where they're filing their patents does give us an indication. This is a phase where it gets expensive. So we tend to be very selective, and we're trying to find the key countries where that's where the business is for these companies. That's where the consumer markets might be. This is where they might be manufacturing their products. Needless to say, Europe and US, we tend to go into. After that, then it tends to be a bit selective on a case-by-case basis. But it is an expensive phase, and we have to be carefully control that element of it. China and India are becoming much more prominent in where we file, especially with China and its manufacturing base. So in summary, from what I've said there, what we're trying to do is closely align our IP creation and its management and what we protect with really where we want to take the technology and where it fits, what it is trying to achieve. We're very surgical in what we kind of license, patent, I mean. And that's because of budget constraints. What we're trying to patent is effectively the most valuable IP and the key IP that will get us to the point where we can license or we can spin out, and it's a key enabler. Usually for most of our patent, for most of our commercial opportunities that we license to companies, the reality is probably only one patent family supporting them. Even in the most extreme cases, I think we've had 4 patent families max. So it shows you how kind of precise and surgical. We don't have the option much to be able to explore wider patent protection. And although hopefully I've laid out some kind of a good approach, hopefully it's relatively clear to you, we do get blindsided by the classic. There's been a public disclosure of the IP, or there is an imminent public disclosure, which means we kind of have to react to that and then probably play catch up on those points that I kind of raised before.
I'm actually going to just stop you there, Geraint, and I know this was your bonus slide, and I'm going to remind people that this was how to contact your TTO or advice on that, and these will be available afterwards. But we have actually got a lot of questions, Geraint, for you, and so I'm going to ask a couple of the questions. One I think was quite a pertinent one, and comes up often, I think, which was, how does a tech transfer office establish a reasonable level of equity to take from spin-outs?
Yeah, and it's quite a red hot question at the moment, given the recent government review. What universities are taking in terms of equity. Well, our current position in Newcastle is that we've kind of got a blanket kind of position. So you can probably access our IP policy. When we establish our spin-outs, we actually take, at the moment, 40% equity in our spin-outs. And we don't negotiate depending on what the nature of that project is. That is the current position. We do recognize we've always been towards the higher end of the spectrum in terms of equity stake. But within that 40%, there's certain things we do, certain percentages, well, a certain amount of the patent costs. There's no need to reimburse that. We free up the founder's time to support the spin out for free to that spin out. We provide, at least in the first couple of years, lab space for the spin outs, which again is free or pretty much at reduced rate. So that's part of the support around the equity. That's the current situation. Going forward, we're having to respond because our 40% equity is kind of out of sync with what the government expects. So going forward, we're going to have to be in a position where we're going to take a lot less equity. We're still in discussions around this and probably won't have this confirmed until the summer. But we're going to take a lot less equity, and there's going to be a lot more flexibility in terms of what the equity stake could be based on the resource requirement that spin-outs could be requesting from the university. So we'll probably be
So I'm just going to wrap you up there, Geraint, so we can get on to Anise. But I think that what you had there was a really sort of useful thing. Yes, the equity is high, but you do get some support back from the university, but things could change to be more flexible in the future. So I'm going to hand over to Anise. Geraint, you've got a lot of questions, or you've got a few questions in the Q&A. If you could type your answers to those. Anise, over to you.
Thanks, Sarah. Hopefully you can see my slides. So I'm going to essentially build on what Catrina and Geraint have sort of built on earlier on in their talks, and also to some degree going to build on what was discussed during Module 2, particularly by Mark White at Northern Gritstone, and really look at how you use your IP to get investment ready, and really sort of peel back some of the layers around IP due diligence. Now, due diligence as a process involves a lot more than just looking at IP. Science and technology we looked at, the people within the team will be looked at, but for this specific IP component, I'm going to go into a bit more detail now. So if you take anything away from my portion of the presentation today, it's these 4 key bullet points, because these are the aspects of an IP strategy that an investment team will really focus in and hone in on in terms of due diligence. They'll want to make sure that ownership, i.e. who owns the IP, what the IP covers in terms of scope, they want to check territories and markets, and they'll need to be sure that you actually have the right to commercialize and launch your product, your medicine, your therapeutic, whatever it might be later on down the line. So these 4 aspects are absolutely pivotal to a due diligence process, and getting these 4 aspects right from the get-go, if you can, will really help attract inward investment going forward. So let's peel back some layers on each one of these aspects now. So generally speaking, IP due diligence can involve investment teams from various different entities, institutional investors such as VCs, corporate investment teams like Big Pharma might come in and have a look at your IP strategy, as well as grant funding bodies. So there's a variety of different entities that apply a due diligence process to your IP, depending on what stage of the commercialization journey or process you're at. The level of scrutiny applied, or the rigor applied during due diligence, generally speaking, is commensurate with the size of the investment. So a multi-million-pound investment will require a high level of due diligence to be applied, whereas perhaps seed investment less than 100K might require a lower level of scrutiny applied during the process. One really nice phrase that was used earlier on in the MDC Connect series in Module 2 by Mark Wyatt at Northern Gritstone was that the IP strategy must necessarily speak to the value proposition, which is a really nice phrase to sort of put the due diligence process in context. What due diligence teams are looking at is that the crown jewels within your business and relating to your technology have been protected by IP rights. And ultimately, if they get to the end of the process and they're satisfied that that is the case, that's a positive for the due diligence process. I always mention during due diligence that it's really important to understand that this is always occurring, generally speaking, pre-investment. So you've not yet secured the investment with the party that are performing the due diligence. So you've got to be really careful about how you share your confidential information during that process to the particular team. Quite often, due diligence will be performed potentially by competitors that are looking to acquire, Big Pharma, other entities that might have a vested interest in this technical field. So bearing in mind you're still pre-investment, be really careful about how you control information. Do you want to use data rooms? Do you use encrypted documents? Do you password protect various different databases and control the flow of information through cloud servers and cybersecurity measures being put in place? So be mindful about the process. Ownership and collaborations. So this is all about making sure the IP is actually in the entity it needs to be in, whether that be in the name of an individual company, be it a spin-out company or a startup company, or whether that should be within the name of the university. And generally speaking, the way to crystallize out who owns the rights in the IP is essentially, in the world of patents at least, is to start at the level of the inventors and who can be defined to be a contributing inventor. Once you've got the inventors in mind, you can then start figuring out what their employment rights were and clauses were, and decipher as to whether the rights in the IP that vest with the inventors automatically transfer perhaps to an employer, or whether they don't. Generally speaking, the law in the UK stipulates that rights will pass from an employee, i.e. an inventor, to an employer, but it's not always the case. A university setting, you will have undergraduates, master's students, PhDs, and postdocs. All of those 4 different types of personnel will have different employment contracts and a different employment status at the university. For example, an undergraduate might well be considered to be a customer or a consumer of the university rather than an employee. So at the bottom line for ownership is understand who's contributed to the invention, crystallize out whether they're employed, and then figure out where the IP rights vest at that moment in time, and make sure by virtue of assignments or contracts that the IP is then transferred in to the name of the entity that requires it for the technology to be progressed and commercialized forward. Like I say, sometimes that's a spin-out company, sometimes that's the university, and sometimes it's individuals. Quite often, innovations come out of joint ventures. You might be working with a different university. You might be working with industry. So when you get involved with those collaborations and joint ventures, make sure you have agreements in place before the project start, stipulating which way any IP might vest. It might be the case that you want to split the IP, or you might want the IP to go one way. But in any event, have those agreements in place, have the conversations early, so that later on down the line, when due diligence occurs, there are no hidden surprises for the investment team that might be uncovered. The investment team will require you to set out all of the information, contracts, potential licenses and assignments, determination of inventors, how they contributed. So be ready to share that with your investment team. When determining inventorship, it's always good practice to have recorded research meetings, recorded all experiments involved with the innovation in experimental lab books, dated and signed at the bottom. Sometimes even brainstorming sessions should be recorded. All of those present at brainstorming sessions noted and the date put down. That way you can really go back over your paper trail and figure out who was involved, why were they involved, and how they contributed. Final point on this slide is around the use of CROs and potential medical device product design agencies. They're really important entities within the drug discovery and medical device discovery setting. But when you do work with them, make sure that, again, all of the terms of IP ownership are set out into service agreements or in a separate contract or agreement before starting the project. I've seen scenarios where SAR has been outsourced out in a small molecule space, and small tweaks to compounds or synthetic protocols done by the CRO end up being inventive, and ownership in inventions can then get split across entities, and very, very difficult sometimes to sort out after the event rather than before. So think about who's contributing at every stage along the way towards commercialization and market, and make sure you've got your watertight contracts and agreements in place to make sure no IP leaks out of the business that you want it to reside in. So coverage, I'm not going to talk about this too much, but patents is generally the area that we focus on the most. So let's talk about patents a bit more. Coverage is what the IP essentially covers in terms of its scope. We really look at whether the product is covered, the candidate is covered. Investment teams will look at that in detail. They'll look at how broad the scope of protection is, i.e. the patent claims, what they cover in terms of how much of the technical field is encompassed. They'll look for whether there are any problematic disclosures that might compromise the strength of the patent. That can sometimes be journal publications or presentations that have been performed pre-patent filing. And on the right-hand side, there's a scenario there where you've got the technical field specified by the big white circle. The grey circle is the patent coverage. Blue is the product and the candidate that you're pushing forward, and purple is the prior art. In this specific scenario, you've got a nice broad claim scope, sufficiently far removed from the prior art, but also covering nicely the product and the candidate, which is great. There are scenarios where you go too broad with the claim scope, you cover off the prior art, that tarnishes the strength of the patent claims and reduces the defensibility of the patent claims. There are scenarios where you go really narrow because of the prior art being very close. The patent scope covers the product and the candidate, but it's relatively focused and narrow as compared to the first example. That's not a showstopper for inventors, but they need to know that that is the case. And finally, sometimes you have patent scopes that don't even cover the product or the candidate. And if that's sort of crystallized out from the due diligence process, that can be problematic. Territories and markets, as Catrina said earlier, patents are territorial rights. So you need to have filed your patent rights in the markets in which you're going to launch or target at least. Patient populations, generic manufacturers, for example, India and China, as Geraint mentioned, are important factors to take into account. And when you're thinking about which territories to file your patents in, you also need to think about the costs associated with filing in multiple territories, because the investors will want to know what are the projected costs of filing the patents and maintaining them. Freedom to operate, as Catrina mentioned earlier, really this idea of looking at third-party rights and trying to assess the risk associated with you launching or commercializing in particular territories. Catrina's already done a really great job of talking to how you do a freedom to operate. And the process you go through is very much similar to Catrina's slide on looking at patentability. That search process was really good, and that can also apply to searching for patent documents as well. But if you do come across patent rights that pose a medium to high risk for you to launch in particular markets, it's quite easy for people just to try and just sort of either sweep it under the carpet or stop the project altogether. But the high risk patent shouldn't necessarily be seen as a total showstopper. There are ways of overcoming those potential obstacles. Negotiating licenses is one. Depending on the size of the entity, the country the entity might be in, or the technical field in which they operate, you could negotiate a licensing deal where the entity commercializes in one territory and you commercialize in another. If they commercialize in one therapeutic space, you commercialize in another. You can always look at the strength of that patent right and check its validity. If you decide or conclude that the validity of that patent is poor and it couldn't be well defended, then you can use that as a bargaining chip to enter negotiations, challenge the validity of the patent and have it revoked at the courts or at the patent offices. So they're more aggressive strategies for trying to clear hurdles. And then also, depending on the claim scope, you could also try to design around the patent claims, and that's quite common in the realms of small molecule development. And Catrina rightly said, make sure your FTO is an ongoing process, because the FTO landscape changes continuously. People are always filing new patents. So if you do an FTO at time point 0, 24 months later, the scenario might be very different. So make sure you are topping up your FTO analysis as you go along. I think we're on to questions.
We most certainly are. Thank you very much there. So we've got some questions in, and one thing around if the IP belongs to the business, if it has transferred through to the employer, what happens to the IP if the business goes under?
Yeah, that's a good question. It's really useful to try to have the IP assigned out if you can before the IP goes under. But quite often, if a company goes into administration, the IP will reside with the Crown legally, and essentially to get that out of the Crown, out of the government, you will be required to go to court and have it extracted and assigned back out to another entity. So that would be the one of the scenarios that might occur. But like I say, quite often what you see is IP rights being assigned out of companies that are going down, sometimes into the names of the previous owners or directors of the company, sometimes into the inventor names, just to make sure that they can maintain that IP from an appropriate position.
And if you can answer this question quite quickly, Anise, how has the EU unitary patent system affected early startups?
At this moment, it's the unitary patent is really kicks in later on down the line when you get granted European patents. You make a decision as to whether to use it or not. So it does affect them to some degree because it will basically lead to more cost-efficient patent maintenance down the line, and also a single patents court in Europe to use in which you can enforce or invalidate patent rights. So in all honesty, it affects entities of all the different sizes from startups through to multinationals. So it does affect startups.
Excellent, thanks very much. I'm just putting my slide back at my final one. So I'd like to thank three excellent talks to our speakers for three excellent talks today, and also for an engaged audience. Clearly you've got them gripped today. We've had lots of questions, and I know you've been busy behind the scenes typing answers. So for next week, it will be the final webinar in this series, and it's around commercializing your innovation. And we have three speakers. We have Claire Turlou, who's head of LifeArc Ventures at LifeArc, and she's going to set out the various options for commercialization. We then have Lillian Alcaraz, who's a Vice President of Early Innovation Partnering at Johnson & Johnson Innovation. And Lillian's going to talk about in-licensing, and in particular, what does pharma look for? And then finally, we have an SME perspective and a case study from Rob Grundy, who's the CEO of Intelligent Omics. And he's going to talk about letting technology address the challenge and working with pharma to commercialize IP. So thanks again for the speakers today. Thanks for your engagement, and we will see you next week for the final one. Thank you. Bye-bye.